So I think we'll get started, everyone. I'm pleased to be able to introduce our keynote for today. Mohammed Fadel, who is Associate Professor and Canada Research Chair for the Law and Economics of Islamic Law at the Faculty of Law at the University of Toronto, which he joined in January 2006. Professor Fadel wrote his PhD dissertation on legal process in medieval Islamic law at the University of Chicago. He was admitted to the Bar of New York in 2000 and practiced law with the firm of Sullivan and Cromwell in New York City, where he worked on a wide variety of corporate finance transactions and securities-related regulatory investigations. He also served as a law clerk to the Honorable Paul V. Niemeyer of the United States Court of Appeals for the Fourth Circuit and the Honorable Anthony A. Alaimo of the United States District Court for the Southern District of Georgia. He has published numerous articles in Islamic legal history and Islamic liberalism, and let me give you just a couple of titles, very randomly chosen to give you a sense of his work. The True, the Good, and the Reasonable, the Theological and Ethical Roots of Public Reason in Islamic Law in the Canadian Journal of Law and Jurisprudence. Public Reason as a Strategy for Principled Reconciliation, the Case of Islamic Law and International Human Rights, Chicago Journal of International Law, and Muslim Reformists, Female Citizenship, and the Public Accommodation of Islam and Liberal Democracy in Politics and Religion. The topic of his talk, his keynote lecture tonight, is Religious Law, Family Law, and Arbitration. Mohammed Fadel.
Well, I certainly appreciate everybody's patience. It's been it's quite, I guess, heroic for you to stay this long to listen to my talk, and I hope I can live up to your expectations. What this talk really, what it's not going to be about, it's not going to be about Islamic law. It's really about political liberalism, and what I think liberalism requires in terms of recognition of pluralism with respect to the family, while at the same time the kind of limits that liberalism at the same time imposes on family life. And I will use sort of Islam as an example of how liberalism, I think, should approach issues of family law, recognizing that Islam is not the only religious conception in the United States or liberal democracies, but just using it as a paradigmatic example that may be especially politically salient. And the basic take-home point is, I think, for the vast vast spectrum of issues, there's really no problem at all. And if you're a good liberal, you should have no problem endorsing family law arbitration. But let me tell you why I think you should reach that conclusion. Now, Western democracies in recent years have witnessed dramatic and often highly charged debates regarding Islamic law, women, and the limits of pluralism in a liberal polity. Perhaps most relevant of these in recent years has been the so-called Shari'a arbitration controversy of Ontario, Canada, which took place between the years 2004 and 2005. In fact, my hire somehow got embroiled in that. People accused the University of Toronto of hiring me in part as part of a scheme to impose Sharia on the people of Ontario, which was funny because I had no idea this was going on at all until I read about this. Anyway, although other religious groups resident in Ontario had long made use of private arbitration for the resolution of intracommunal family disputes, when a group of Sunni Muslims announced their intent to establish a mechanism to allow Sunni Muslims to arbitrate their family law disputes in accordance with their understandings of Islamic law, a transatlantic controversy erupted that was resolved only when Ontario took the drastic step of prohibiting the arbitration of all family law disputes in which the arbitrator purported to apply non-Canadian law. Great Britain, too, experienced its own moment of Islamic law anxiety when the Archbishop of Canterbury suggested that British commitments to pluralism might require the English legal system to recognize certain aspects of Islamic law. That controversy was subsequently heightened when it was revealed that British Muslims had indeed already set up judicial councils that engaged in legally binding arbitration of family law disputes, pursuant to already existing British law permitting binding arbitration. The debate surrounding whether to permit binding family law arbitration, particularly when such arbitrations are based on religious or otherwise non-liberal legal systems, raises many important and difficult questions from the perspective of liberal political theory, because it forces a confrontation between various core values within the liberal tradition, particularly gender equality and religious freedom, or even more generally, the conflict or potential conflict between liberalism's egalitarian commitments and its commitments to personal and also associational autonomy. I will try to answer the question whether the results of religiously based arbitration of family law disputes should receive legal recognition from the perspective of political liberalism. I will begin with a discussion of the role of the family within political society as described by John Rawls in his discussion of the family and the idea of public reason revisited. Following that, I will discuss why we should expect religious conceptions of the family to conflict in certain respects, in certain important respects, with the politically liberal conception of the family, using certain examples from some aspects of Muslim family law. Third, I will discuss Rawls' conception of reflective equilibrium and argue that arbitration is, from an institutional perspective, an effective tool, maybe even a catalyst, for generating a reflective equilibrium between public conceptions of justice and non-conforming conceptions of justice, including religious ones. I will illustrate this potential for arbitration to act as a catalyst for producing a reflective equilibrium by discussing Islamic conceptions of distributive justice within the family and comparing them to the default norms that apply in North American family law. Canada. Since I'm a Canadian now, I can never just say America. I will conclude with a discussion of whether arbitration in fact can act as an effective tool for protecting the autonomy of individual religious believers while vindicating liberal commitments to the political role of the family in a democracy. One of the central objections to the legal recognition of Islamic family law arbitrations raised at the time of the Shari'a arbitration controversy in Ontario was that Islamic law would conflict with Canadian commitments to gender equality within the family. The meaning of equality within the family, however, remains deeply contested even among liberals. And even religions that are commonly viewed as endorsing a patriarchal family structure have their own conceptions of gender equality. Islam, for example, teaches of equal moral worth of men and women, and the New Testament states that men and women are, quote, all one in Christ Jesus, unquote. Equality, therefore, can mean radically different things, especially in connection with its application to particular disputes. Numerous plausible, though incompatible, theories could be advanced regarding the family that are consistent with some version of liberal equality. For example, one could take the view that gender equality in marriage should be viewed as a matter of distributive justice, in which case equality means that men and women should receive an equal share of the benefits of married life. One potential drawback of such a conception, however, is that it would not exclude marriages organized around a gendered division of labor, if such a marriage in fact did result in an equal or relatively equal sharing of the burdens and benefits of marriage. And in fact, there is a lot of empirical evidence that oftentimes traditionally structured marriages do result in some kind of rough justice between the parties, and certainly a great amount of happiness for those that find that an attractive model. Alternatively, equality within the family could produce a conception of marriage as, quote, an egalitarian liberal community, unquote, that resists individual accounting of deserts. But such a conception would preclude traditional homemakers from receiving any tangible rewards for non-market services they perform in the household. Some feminists, however, argue that marriage should be treated in a manner analogous to a partnership, in which case equality would require valuing the individual contributions of each spouse to the family, including the non-monetary contributions historically provided by wives in the form of child rearing and housework. Now, the problem with this conception, however, is if this care work, as it's known, is monetized, it might in fact encourage women to continue to specialize in household rather than market production. Of course, this would have the intentional effect of reinforcing the very gender division of labor that many feminists have traditionally sought to eliminate as being the cause of female inequality. So the commitment to equality, right, is often in the eye of the beholder. It's very controversial, and it's not quite clear which conception is right, and each one comes with different sort of advantages and disadvantages. Right? Now, political liberalism does not attempt to determine which of these liberal, or for that matter non-liberal, conceptions of equality is correct. It instead regulates the family from the perspective of what is required, quote, to reproduce political society over time, unquote, in a manner consistent with its ideal of treating all citizens as free and equal. Because the family is part of political society's basic structure, labor inside the family, according to Rawls, is socially necessary labor. On this account, the family is an association, and therefore the principles of justice, including distributive justice, do not apply directly to the internal life of the family. They are only relevant in a negative sense, meaning that the basic rights of women as citizens place limits on permissible forms of family organization. The public constraints of justice on matters of internal associational life must not be so severe in Rawls' view, however, as to constrain, quote, a free and flourishing internal life of the association. Right? So according to Rawls, a family is a kind of association, but it's a particular association because it has the responsibility of reproducing political society over time. So principles of political justice apply to it, but not in the same way that it applies to purely public institutions like courts or legislatures or other elected officials, right? But they are still relevant, okay? So it's in a median position between public institutions and associations. On the one hand, the family, because of its essential role, is part of the basic structure of the society. On the other hand, it is a voluntary association, and thus the principles of justice cannot apply to it in the same way that the principles of justice constrain a wholly public institution. Rawls' analysis of the family, therefore, has important implications for equality within a system of family law that is politically liberal, or it should. It tolerates the continued existence of inequality within the family, but on the condition that such equality, according to Rawls, is, quote, fully voluntary. Religiously justified hierarchies of the family, therefore, are consistent with the principles of justice, according to Rawls, if the background conditions of political justice are reasonably met. So according to Rawls, the only gender-based inequality that must be abolished as a matter of the principles of justice is involuntary gender equality. Religiously justified inequality satisfies the voluntariness requirement, according to Rawls, because in a politically liberal regime, adherence to religion by definition is voluntary. While Rawls appears indifferent as to whether the burdens of labor in the family should be shared equally between men and women, or whether it is enough for women to be fairly compensated for taking on a disproportionate share of such labor, he insists that justice requires that one of these two possibilities be satisfied. So either, there's equality in kind, right? If there's not equality in kind, then women have to be systematically compensated, or they're taking on a disproportionate share of family labor. So for Rawls, I think it's fair to say that family law plays a secondary role in guaranteeing gender equality, because he assumes that women enjoy all basic rights of citizens and also have access to the material means necessary to allow them to make effective use of their liberties and opportunities. In such circumstances, any residual gender-based inequality can be assumed to be voluntary, at least from a political sense, according to Rawls. So as long as women are being fairly compensated for any additional work they take on with respect to reproductive labor, measured, of course, against the hypothetical baseline of reproductive labor that reflects a gender-neutral division of such labor, and the background political conditions are otherwise just, then, according to Rawls, political liberalism really has nothing to say about the internal organization of the family, even one that explicitly endorses a gender division of labor. Now, while political liberalism seeks to regulate the family from the perspective of its role in the reproduction of political society over generations, primarily by ensuring that the family plays a positive role in nurturing the next generation of citizens in a fashion that is consistent with basic constitutional values, religious conceptions of the family are generally organized around much broader concerns, such as reproducing the way of life of a particular religious community, including its particular conception of good, and in the case of salvation religions, preparing the ground for its members' ultimate salvation. The much broader concerns of religious regulation of marriage are reflected in the importance that traditional religions accorded marriage, which was often viewed as a relationship that included both secular and worldly concerns. And this is really, I think, the important source of the conflict here, is that political society is, of course, terribly concerned with the regulation of the family because that's how it survives. Religion is terribly concerned with the family because that, too, is how it survives. But they are concerned with very different things. Religion has different ends than the ends of political society, particularly a politically liberal one. And this is where the challenge is. How do you reconcile the fact that we have two different views of the ends to which family is supposed to serve? In terms of Islam, marriage is viewed as so significant to one's standing as an upright member of the community that it is often referred to as half of one's religion. So one might say, when he or she wants to get married, I want to complete half my religion, instead of just saying, I want to get married. Marriage is viewed as indispensable to an individual's spiritual well-being because, among other things, it allows for the illicit expression of sexual desire. It is also generally productive of the thick web of family relations, not only because most marriages will produce children, but also because it is expected that marriage will generate important ties of social and moral solidarity among the families of the spouses. At the same time, however, marriage represents a critical secular institution that was probably more important to the secular lives of their members than any other social institution with which an individual would interact during his lifetime. Historically, marriage involved the formation of a household and generally triggered what were often substantial transfers of property. It imposed a regime of economic rights and responsibilities among the members of the household and sometimes others in an extended family relationship. It established rules for the intergenerational transfers of wealth. It established rules for affiliating children to parents and assigning financial and nurturing responsibility over them. And it established rules for the dissolution of households, at least in Islam, along with a substantial body of rules governing ongoing economic relations among former members of a household. In considering how Islamic conceptions of marriage interact with liberal ones, therefore, it is always crucial to distinguish, to the extent possible, those Islamic commitments which are religious in nature from those which are more narrowly legal. Now, since we've been sort of talking about this theme regularly in the conference, let me just say very quickly what I mean by religious commitment as opposed to a secular one. So in Islamic law, we talk about an intent to draw near to God, right? So if a rule, the purpose of the rule is to further one's relationship with God, then I call that a religious rule because it formally requires a religious intention, which is called niyyah in Arabic. And then there are other rules whose validity and applicability are completely independent of people's subjective intentions, right? And so I call those secular rules. Now, Islam as a legal system regulated the formation of marriage contracts by stipulating who had the capacity to enter into such contracts, the conditions for the validity of such contracts, the remedies for defective marriage contracts, as well as remedies for breaches of a marriage contract. Because of the existence of legal pluralism with Islamic law, numerous potential answers exist for all of these various questions, some of which may be, from a substantive perspective, more in conformity with liberal values of equality, and others less so. As a general rule, however, Islamic law's treatment of the family was highly gender structured, with men and women assigned different rights and obligations within the household, with men generally expected to specialize in economic production outside the household, and women specializing in domestic and reproductive labor inside the household. Likewise, Islamic law afforded men the prerogative to divorce their wives at will, as well as the right to marry another woman while remaining married to their first wife, without granting a reciprocal right in the wife. Men also had a qualified right to discipline their wives, including the privilege of using force in limited circumstances. Inheritance rules also provided that males of the same class received twice as much as a similarly situated female. For example, a widower would receive 1/4 of the estate of his deceased wife, while a widow would receive only 1/8 of the estate of her deceased husband. Likewise, sons also received twice the share of similarly situated daughters. The rules governing custody and guardianship of minor children were also gendered. Accordingly, upon the dissolution of a marriage, if there were children, the mother would generally be awarded custody of the couple's minor children. But upon the children reaching a specified age, which differed for sons and daughters, and at least in some cases, the father would become the custodial parent. The father, however, in all cases, no matter what the age of the child, was entrusted with legal guardianship from the time of their birth until such time as the children became legally adults. The gendered structure of rights within the family could be remedied to a certain extent through the device of contractual stipulations at the time of the marriage contract or even after the marriage contract. Accordingly, a woman could obtain a condition that would prohibit her husband from exercising his right to marry a second wife without her approval, or would require him to grant her the option either to divorce herself or divorce the second wife. These were very common contractual stipulations. She could also stipulate the right to divorce her husband at will, at least according to some versions of Islamic law. Likewise, the gendered rules of inheritance law could be, I don't like to use the word circumvented, but their effect could be nullified almost in their entirety through other lawful means of intergenerational wealth transfers, such as inter vivos gifts, which were themselves subject to an explicit norm of equality. So gender was not considered a relevant basis for discrimination with respect to inter vivos gifts. Likewise, Islamic law permitted property owners to establish trusts in which they could divide beneficial interests in the property any way they wished. Again, as long as they did that in their lifetime. So the system of intergenerational wealth transfer in Islamic law is much more complex than that of the inheritance system. The inheritance system is one portion of it, but you also have inter vivos transfers, whether outright gifts or through trusts, in which there was basically complete freedom for the donor to do with the wealth as he wished. Religious norms, however, emphasize the spiritual element of marriage, such as the notion prevalent among some Muslims that marriage is a ritual that has otherworldly significance in addition to its secular functions. This ritualistic view of marriage, in turn, encouraged, in many cases, an ethic of sacrifice and self-abnegation, particularly among females, in the name of preserving the family, and promised women special religious merit for bearing with patience, for example, abusive husbands. Likewise, there was the popular conception that divorce is, even if it's legally permissible, it's a very bad thing, and people should exert their utmost in forbearance without resorting to this remedy. So it was encapsulated in a saying that was attributed to the Prophet that the most detestable of permissible things to God is divorce. Religious ideals also influenced the way jurists interpreted provisions in marriage contracts. Instead of interpreting contractual provisions using an assumption of arm's-length bargaining that would be appropriate for commercial contracts, mushahat, that's what the Arabic term is, they interpreted stipulations in marriage contracts often under an assumption that marriage contracts were to be construed pursuant to a norm of mutual generosity and forgiveness, mukarama. Sometimes such an assumption could be favorable to women, like the rule adopted by one school of Islamic law that breaches of representation that were irrelevant to the wife's ability to perform the marriage contract, for example, a representation of physical virginity, were not legally actionable if they were breached. But at other times, they could be disadvantageous to women, such as a rule that a woman's contributions to household expenses, although legally a loan and thus a debt repayable by the husband, converts to a gift if the wife fails to enforce her claim against the husband in a timely fashion. Despite the gendered nature of Islamic law, I've argued elsewhere that there are good reasons to believe that many of these rules represent neither categorical Islamic commitments, nor would it be implausible to believe that Muslim citizens of liberal regimes would be more inclined to adopt interpretations of Islamic law that are more, rather than less, in line with the values of gender egalitarianism. I've also argued that the very same extra-legal religious discourse that was used in the pre-modern period to justify an ethic of self-sacrifice can be expected to take a very different, more egalitarian turn in the context of liberal regimes, where even religiously conservative Muslims tend to interpret the religious aspects of marriage in a more gender egalitarian fashion. The question here is whether the arbitration of family law disputes can be viewed as a normatively justified institutional solution to the conflict between liberal family law norms and religious family law norms. So I don't need to revisit, all my substantive arguments about the substantive rules of Islamic law. I just want to think now more about, is family law arbitration normatively justifiable from the perspective of liberalism? Now, as discussed above, political liberalism, in its Rawlsian version, recognizes a certain degree of pluralism within the family. Pluralism is tolerated within the family because the role of the family, from a political perspective, is limited to the reproduction or contributing to the reproduction of political society. Physically, by having children, and morally, by inculcating in them the values of good citizenship, or contributing to the teaching of citizenship. It's not the only institution for that, but it is an institution that teaches political values. Permissible forms of family life, therefore, may be restricted according to Rawls in light of these goals, but not in furtherance of any other goals, right? So while it's okay to restrict family life in light of the political goals of political liberalism, it is not okay, according to Rawls, to restrict family life for other reasons. Because that would violate the equal freedom of individual citizens to pursue otherwise reasonable conceptions of the good. Right? So as long as the family is furthering the political conception, right, they should be free, according to Rawls, to organize their lives in a way that furthers their own conception of the good, which may include a certain amount of gender inequality that's justified on religious grounds. The fact that religious communities are permitted to pursue their rational conceptions of the good within their families, however, does not necessarily argue for recognizing a right to arbitrate family disputes pursuant to the norms of that community. Now, I don't want to take the position that political liberalism mandates the recognition of such a right, but I do think that I'm going to defend the view that the qualified right to arbitrate family law disputes is deeply consistent with the ideals of political liberalism. And in fact, it may be an ideal institution for effecting the kind of interaction between public principles of justice and the internal norms of various religious communities that may reject some applications of those norms. Right? So it could be an ideal practical institution for effecting the kind of reconciliation between public doctrines and non-public doctrines that Rawls views as essential to generating stability of the social contract for the right reasons. Right? It helps contribute to a consensus. This is so because one of the central values of political liberalism, perhaps its most crucial value, is the hope that we can generate terms of political justification to which all reasonable citizens can agree. Rawls derives his account of the principles of justice using a heuristic of the veil of ignorance. But in order for such an arrangement to be practical and stable in the real social world, it is necessary for a reflective equilibrium to exist in the minds of reasonable citizens that reconciles their actual subjective convictions with the principles of justice that are derived through this abstract process. As Rawls describes it, a reflective equilibrium results from a dialectical process between our considered convictions and the results of our theoretical inquiry resulting from the original position. It comes into existence when, quote, our principles and judgments coincide, unquote. But even after reflective equilibrium is reached, quote, it is liable to be upset by further examination of the conditions which should be imposed on the contractual situation, and by particular cases which may lead us to revise our judgments. So in other words, we can engage in this exercise of the original position behind the veil of ignorance. We can draw up what we consider to be the principles of justice. But in an important sense, these are provisional. Because as we sort of live and gain social experience, we might encounter new cases that might cause us to revise what we consider to be our principles of justice, because we discover that we made a mistake in our setup of the original position, right? So just as Rawls envisions individuals engaging in a dialectic between their subjective ethical commitments and the results of their philosophical inquiry until an equilibrium is reached in their minds, it is possible to imagine a similar process taking place between the public institutions of justice, represented by courts of law, and the internal norms of a religious community. Public arbitration provides an institutional forum in which a dialectical process that helps to generate a reflective equilibrium, to use Rawls's term, or to use Rawls's term from political liberalism, help generate an overlapping consensus. Binding arbitration can perform the salutary function of deepening an overlapping consensus with respect to a liberal society's political commitments to both religious freedom and gender equality, because it empowers private parties to adjudicate their disputes pursuant to their own rules, provided that the results do not contradict mandatory principles of justice. The process of binding family law arbitration therefore mirrors, in institutional terms, the relationship between the family and the principles of justice as Rawls envisions. Pluralism, while presumptively permissible within the family, is subject to the limits demanded by the principles of justice. Accordingly, arbitration, far from insulating a religious community's practices from the principles of justice, acts to confirm that a community is applying its norms in a manner consistent with those requirements. At the same time, binding family law arbitration, particularly when performed by religious communities, provides public institutions, as represented by courts, an important opportunity to determine whether mistakes have been made in the formulation of the principles of justice. In other words, it allows a feedback mechanism where new experiences can be obtained, and that can sort of allow for a gradual change in the background conditions of the law as we learn more. Right? Arbitration, it should be clear, is limited to such issues as the parties themselves have the legal authority to resolve by consensual agreement. This is a very important point. The right to submit family law disputes to binding arbitration is therefore an extension of the party's own contractual freedom. It is also limited by the contractual nature of arbitration. The parties to a dispute cannot, for example, arbitrate the rights of third parties, such as that of children, or matters of criminal law or civil status, such as whether or not a person will be married or divorced, right? Because those are not within the contractual parties of individuals. So what this means in practice is that binding family law arbitration is generally limited to financial matters between the spouses, such as division of marital property or future support obligations, or both. While many opposed to recognizing binding family law arbitrations conducted pursuant to Islamic law have pointed to the disparate rights given to men and women under Islamic law, in the vast majority of cases, the discriminatory rules of Islamic law, for example, different rights to divorce or child custody, could never become the legitimate subject of a binding family law arbitration, because arbitrators can never have that power to award child custody, right, or to grant a divorce. Islamic law, however, does include its own rules regarding the distribution of marital assets and post-marital support obligations that are generally inconsistent with the prevailing approach to these questions in North America. First, there is no concept of marital property in Islamic law. Both parties enter the marriage with their own property entitlements fully intact, with some qualifications that are of little importance in this context. Second, so long as the marriage remains intact, the husband is under a non-waivable obligation to maintain his wife, regardless of how wealthy or poor she is, and to maintain his children until they reach the age of majority, again, regardless of how wealthy or poor they are. And in the case of minor boys, in the case of minor girls until they're married. Third, upon dissolution of the marriage, the husband's obligation to maintain his wife for all practical purposes comes to an end, although he is encouraged to give her a departing gift. Now, to what extent does political liberalism require some kind of redistribution of household assets that approach equality as a condition to respecting the party's private resolution of their claims? Rawls seems to suggest that it does, right? He states in The Idea of Public Reason Revisited that because reproductive labor and household labor are both socially productive, they must be compensated. Moreover, he suggests that the preferred mode for compensating women for their specialization in household and reproductive labor is to award them the equivalent of a partner's interest in their husband's earnings during the marriage. Let me quote this paragraph. He says, "But now a common proposal is that as a norm or guideline, the law should count a wife's work in raising children, when she bears that burden, as is still common, as entitling her to an equal share in the income that her husband earns during the marriage. Should there be a divorce, she should have an equal share in the increased value of the family's assets during that time. Any departure from this norm would require a special and clear justification. It seems intolerably unjust that a husband may depart the family, taking his earning power with him, and leaving his wife and children far less advantaged than before. Forced to fend for themselves, their economic position is often precarious. A society that permits this does not care about women, much less about their equality, or even about their children, who are its future. Yet this is what Islamic law appears to do. Upon dissolution of the marriage, the husband is entitled to depart with his earning power. Yet it is far from clear that Islamic law's refusal to recognize an ongoing post-divorce maintenance obligation akin to traditional alimony, or even an obligation to allow the wife to share in the increased value of the family's assets during the term of the marriage, inevitably leads to the stark conclusion that Islamic law, quote, does not care about women, much less about their equality or even about their children, unquote. Indeed, it would be extremely implausible to believe any society could long exist if it were truly indifferent to the fate of its women and children in the manner Rawls seems to suggest might be the case if the rule that he advocates is not really adopted. While it is certainly true that as a default matter, most jurisdictions in North America adopt a presumption of equal sharing of assets acquired during the marriage, parties are permitted to depart from that norm, whether by entering into a valid prenuptial contract or pursuant to a settlement agreement concluded at the time of divorce. So parties in the United States and Canada are free to adopt their own norm of distribution of marital assets, whether ex ante, through a prenuptial agreement, or entering into a separation agreement, right? So, and it's not really clear that Rawls's preferred solution is actually the law either in Canada or the United States. In both cases, so long as the terms of their agreement are untainted by unconscionability, courts will enforce them in accordance with their terms, right? So it's actually not the case that special circumstances are required. It's extraordinary circumstances when these private agreements will not be recognized. That's the state of the law today. And indeed, there's a very recent case in Quebec, which is quite interesting, because Quebec is sort of, in some respects, it's much more robustly egalitarian than, say, Ontario, which is more of a common law as opposed to the civil law tradition. And there we had a case where a woman had lived for many years with her partner, and they never married. And Quebec has, I believe, community property rules which are very hard to evade. But she never got married, right? They were never married. They lived together as what we call in Canada de facto spouses, right? So when she and her partner split, she brought a suit claiming that she should receive all the benefits of a de jure spouse, and that it was unlawful discrimination, a violation of Section 15 of the Canadian Charter of Rights and Freedoms, that she should be deprived of the protections of the Quebec Family Law Act simply because she never went through the formal process of getting married. Okay, so there's a radical difference in distribution between de jure spouses and de facto spouses, right? She's de facto spouse. She wants to get the benefits of being a de jure spouse. The court, however, the Supreme Constitutional Court in Canada, rejected the argument and said that there is no violation of equality here, in large part because this would amount to an undue interference in the autonomy of individuals in Quebec to choose whether they want to live under the de jure regime, subject to these strict rules of property distribution, right, or live together as de facto spouses, in which a much less generous scheme of distributive justice would apply upon the termination of the relationship. Not all scholars, moreover, are convinced that an equal sharing of marital surplus is the appropriate rule, rather than, for example, a norm based on unjust enrichment, pursuant to which one spouse, the husband, for example, would compensate the wife for the value of the services she provided to the household during the term of the marriage, as well as the opportunity costs he incurred for specializing in household production. Indeed, from an ex-ante perspective, it's not clear which rule would consistently further the material interests of women who specialize in household and reproductive labor. If she is fortunate enough to marry a successful professional, for example, the sharing rule recommended by Rawls might be preferable, unless, of course, the couple failed to amass any significant savings because they preferred to consume it immediately. Right? When marital assets are scarce, either because the husband wasn't a good earner or because the couple dissipated his earnings, she clearly would be better off with a remedy that simply compensated her for her contributions without regard to the value of the household's wealth. The point is that unless women are given an option to choose which of the two remedies makes them better off ex post, a possibility that itself seems unfair, Rawls was perhaps a bit optimistic when he suggested that a strong rule in favor of equal sharing should be mandatory in most circumstances. Indeed, it would seem that the answer to the problem of female specialization in household and reproductive labor should not lie so much in the earnings of the other spouse, but rather in the public, insofar as Rawls is correct when he asserts that household and reproductive labor is socially necessary labor that must be compensated. Accordingly, one might say that no society that truly respects women and children if their economic security is dependent largely on their ability to form and maintain intact family relationships. I mean, I think the real question is, why do we depend on the family to provide economic security to women and children? Viewed from this perspective, there's nothing necessarily sinister about Islamic law's approach to the distribution of property upon the termination of a marriage. Instead of judging whether a particular distributive norm is, on its face, consistent with the equality of women, it might be more important to determine whether, if as a result of a divorce, the woman is left in a precarious economic position solely as a result of the divorce. There are at least two reasons to think that why this might not be the case in the event that Islamic law of property is applied by arbitrators to the dissolution of a household governed by Islamic law. First, because Islamic law recognizes the independent property rights of a wife, and it requires the husband to make a marital gift of property to the wife at the time of the marriage, it could very well be that her marital gift has substantial economic value. Earlier today we heard a case where a woman had a claim to almost $700,000 pursuant to this idea, but then the court struck that down. But I suggest that, if that's what she gets, she's probably not in a situation of being economically precarious, and there would be no reason for us to worry about that. Second, because Islamic law does not require a wife to contribute to the household's expenses. If the wife worked outside of the home, she might already have a substantial sum of money in her own name that she's saved from her own market labor. If, on the other hand, she used her earnings to offset household expenses, it is not unreasonable to believe that a Muslim arbitrator could deem such sums to be loans to the husband, which he must repay at the time of divorce. An arbitral award based on the combination of her marital gift and the economic value of her household contributions, if she did not work outside the home, or if she contributed her income to the household cases in where she did work, could very well prevent the result that Walls was rightly concerned about in the previously quoted passage, namely, that divorce should not leave women in an economically precarious position, at least in circumstances where marriage had provided her some sense of economic security and she had been an active contributor to the welfare of the household. Of course, it is possible that an arbitrator applying Islamic law could fail to take into account the wife's non-monetary contributions in the household when he is determining how much household property should be allocated to the wife. This might be particularly a risk in the stereotypical household characterized by a professional husband who specializes in market labor and a non-professional wife who specializes in domestic and reproductive labor and thus lacks any skills that are valuable in the market. It may even be the case that some Muslim men in such a position would prefer to use Islamic law in an effort to minimize the amount they would have to pay their former spouses. It's also true to say the reverse is true, where if you have a Muslim woman who earns a lot more money than her Muslim husband, might prefer to use Islamic law to avoid any kind of maintenance obligations she might have to her husband ex post. Right? But the point here is such a motivation in itself is not wrongful from a political perspective, as evidenced by the fact that only unconscionable prenuptial agreements and separation agreements are enforceable. The mere desire to reduce one's obligation to an ex-spouse is not generally considered a legal cause for not recognizing their agreements. So as long as the arbitrator's award does not lead to an unconscionable result, it is hard to understand why there should be a principled objection to an arbitration based on principles of Islamic law that lead to an unequal but not unconscionable distribution of household property upon divorce. But the reason, the risk that there might be an unconscionable distribution, right, because of bias in the arbitrator or ignorance on the part of the arbitrator, of course, that's why we have to have public arbitration, right? Because we need to make sure, in fact, that these arbitral awards do not violate these minimum standards. But what about the argument that arbitrations conducted pursuant to Islamic law ought not be respected, regardless of their substantive conformity with minimum norms of fairness, because this would amount to a public recognition of a mode of deliberation that is overtly discriminatory against women, and thus could be said to be expressively discriminatory, and on that ground contrary to public policy. I've seen this argument in some cases. Now, this argument might be plausible if Islamic law could be construed as endorsing unequal distribution of household assets as a means of expressing a dogmatic view, for example, that marital breakdown is always the fault of women, and therefore women must be punished when divorce occurs by giving them a very trivial amount of marital property. In fact, however, the distribution of household assets in Islamic law is a result of gender-neutral principles of property law, which in certain circumstances, for example, the high-earning professional male and the woman who is 100% dependent on her husband's earnings, because of her complete specialization in household and reproductive labor, favors the male. But in other circumstances, it could equally favor the female. For example, if the female works outside the home, earning an income equal or nearly equal to that of her husband. Because in that situation, she would be able to keep all of that for herself. Because the application of Islamic law governing the distribution of marital assets does not communicate a message of female inferiority, and in many cases could result in a distribution of material assets that in fact is skewed in favor of the female relative to the norm espoused by Rawls and other liberals, it is hard to understand on what grounds one might argue that recognition of even substantively fair arbitrations conducted under Islamic law should not be enforced because they undermine fundamental commitments to gender equality on some sort of expressive grounds. Finally, one might conclude that as a theoretical matter, liberal family law ought to permit binding arbitration of family law disputes in accordance with religious norms in the proper case, but still object on the grounds that as a practical matter, religiously inspired arbitration will effectively shield the discriminatory practices of religious communities from public scrutiny. Accordingly, parties to a family law arbitration might enter into an agreement that effectively insulates the results of the arbitration from meaningful judicial review. Again, this objection was very common in Ontario, that if you allow religious religious arbitration, courts will never be able to determine whether or not the results were fair. Now, this objection appears to confuse the power of courts to review the substantive decisions of an arbitrator with the power of a court to determine as a threshold matter whether a particular legal claim is amenable to arbitration. While it is true that courts are highly deferential to the substantive decisions of arbitrators on the merits of the party's claim, they review de novo the threshold jurisdictional question of amenability to arbitration. This is the path family law arbitration has taken in numerous decisions of New York courts involving disputes between Jewish couples who had submitted or agreed to submit some or all of their family law disputes to Jewish religious courts for resolution. The New York case law is clear that as a threshold matter, the court is to determine whether the dispute is amenable to arbitration, i.e., that it does not involve some matter of mandatory public law that cannot be resolved by arbitration. Because matters such as division of marital assets and post-divorce spousal support are not, as a general matter, subject to public policy restraints, they are presumptively amenable to arbitration. Of course, provided that the procedural requirements are met and the results are not unconscionable. And in these cases, arbitrators' decisions will be enforced subject to perfunctory review. Right? Decisions regarding child custody, however, are not amenable to arbitration because that would violate mandatory public policy, which in New York requires the court to determine that custody arrangements are, quote, in the best interests of the child. New York courts also specifically enforce the obligation to arbitrate the dispute, even if the arbitration agreement provides for religious norms to govern the arbitration. More controversially, perhaps, they refuse to find that an agreement to arbitrate could be set aside on the grounds of duress, where a woman was subjected to the threat of, quote, shame, scorn, ridicule, and public ostracism, unquote, by the members of her religious community if she did not agree to participate in the arbitration. Right? Again, here I think this is sort of consistent with Rawls' idea that when we look at voluntariness, we're looking at voluntariness from the perspective of political voluntariness, not some kind of deep, subjective, psychological voluntariness. And individuals as citizens sometimes have to make hard choices, right? Are they going to are they going to be members of a religious community, in which case they might subject themselves to shame, scorn, ridicule, and public ostracism if they violate those norms? Or do they want to exit that religious community and sort of give up those benefits, but have the freedom to live their lives without such threats, right? But the New York court agrees that that does not constitute legal coercion. Right? In short, the jurisprudence of New York courts with respect to family law arbitration seems to be to enforce agreements to arbitrate and to enforce the results of such proceedings to the same extent that the court would enforce the parties' own agreements, which I think is the right approach, right? As long as there are no violations of public policy and it's within the contracting powers of the parties. Okay. And this is consistent with a politically liberal conception of family law. This approach understands that the function of public law in the context of the family is to ensure that the internal governance of the family does not deprive any of its members of their fundamental rights as citizens. And as long as that condition is satisfied, the family should enjoy autonomy. This approach contrasts with the categorical approach taken by those who would, in principle, refuse to recognize the results of family law arbitrations that apply a religious family law. The success of New York courts in policing family law arbitrations in the Orthodox Jewish community of New York, however, suggests that courts could easily apply the same principles to arbitrations conducted pursuant to Islamic law as they have done with Jewish law, right? So that if we are worried that Muslim arbitrators are going to systematically undermine norms of public law by, for example, affirming unconscionable property divisions or ruling on issues outside of their arbitration, we can trust that courts will not recognize such arbitrations. So to conclude then, it seems that there are very good principled reasons to believe that family law arbitration is a good thing from the perspective of political liberalism. And the prudential reasons for not recognizing are more a criticism of courts than they are of religious communities. Thank you.
Yes. If I understood your example, under Islamic law, a man and a woman live together for a long time. They want to separate. And the woman wants part of the assets. And the court ultimately rejected her claim, correct?
Okay, we'll keep going.
In that illustration you gave us. What if they would have had children?
Well, I mean, what I'm saying is that the wife's claim, the wife cannot, neither spouse, it's not the wife, neither the male nor the female can make a claim to property based simply on the fact of marriage. Because in Islamic law, marriage does not create a separate estate, right? They each have their own property entitlements intact. Okay? So the wife might have claims, for example, that she contributed to the household over 30 years, right? That would be a debt that she would be able to enforce against her husband, right? But it wouldn't be necessarily a specific piece of property, right? We'd have to. So the point is that marriage does not create a separate marital estate, right? That's the basic point. There might be other claims, monetary claims, etc. Right? Now, as far as children goes, for example, when a woman is acting as custodial caregiver, right, she has to be compensated for that. So the father has to support the children and reimburse the mother for taking care of the children, right? As well as providing them a house, etc., etc.
Even though they were not legally married?
Even though they're no longer legally married, right? Because as a custodial caregiver, she has certain claims against him.
Thank you.
Any other questions?
As you said that marriage does not create a marital property between the two of them, and each one has entitlement to whatever they had before.
And whatever they earned during the marriage.
During the marriage. Now, is this sort of idea general across the Islamic world that during the marriage, the man's property can be shared by the woman?
Well, he has to. He has an obligation to maintain the spouse, right?
But he cannot access or help himself, so to speak, to her property.
That's right.
So, in that way, how equal is that type of
Well, it's not equal.
It's
not equal, right? That's my point. It's not equal.
Isn't it reverse discrimination, so
well,
to speak?
I mean, I don't, it's not equal, right? You can argue about who benefits more from it. The point is it's not equal. Because she has no obligation to maintain him or their children while he does. And so that means she can take his money, he cannot.
He cannot.
He cannot, right? But that's part of the point is that there's not, it's true that there's not an ongoing marital obligation post-divorce, but inside also, she doesn't give up her property. Like for example, in common law, a woman's property interest would vest in the husband at marriage, right? So I mean, one of the points that I didn't bring out here, but I brought up in another paper, is that many of our remedies assume a certain conception of marriage that is deeply historical and ultimately sectarian in its own conception of marriage and how marriage works and the rights that marriage provides to spouses. But if you vary the presumptions, right, the results can be sensible from a different perspective, right? If you just look at one rule, it looks crazy. But if you look at a complex of rules together, it doesn't look crazy.
So I'm a little hesitant to ask a question of such an erudite legal talk that come from a philosophical perspective, but I do want to warn you that you invited it by talking about law so much. But my question is very much a philosopher's kind of question. It's somewhat on the abstract level, and I don't know what concrete applications of that. I thought it was very interesting at one point early on when you said religion and the state have similar interests in the family because that's what reproduces their kind of society. And I think that's exactly right. And actually, I hadn't thought of it quite in those terms before, but it was, I thought, a clarifying moment. But you could also say that it's precisely in that common interest that you can see most sharply the differences, too. Because what the religion, and this doesn't apply just to Islam, but religious groups in general, have interest in reproducing the religious character of the society, that is, raising the children in particular, and perhaps the spouses in an environment that is close to God in various ways. And the state isn't necessarily opposed to that, but certainly the Rawlsian state is primarily interested in raising citizens, that's the big focus, especially in the later Rawls, who are free and equal and free to make choices, free to exit all their agreements, including their family agreements and so forth. So one would think that there will be a number of cases, many kinds of cases, though I have to say it seems to be those will primarily have to do with educating children. They could have to do, especially with educating daughters, with raising the gender issues. It could have to do with the wife's participation in various activities which on the religious level are considered to be too public or something like that, where the state will have, certainly the Rawlsian state, precisely the opposite interests of the wife or the children. But it seems like you've narrowed the range, so my question is, what practical implications does this have? It sounds like you've narrowed the realm in which you want the state to allow for arbitration, that the kinds of issues I'm concerned about won't be.
I agree with everything you said.
Okay.
Right? That there will be a host of conflicts because the state, particularly a liberal state, politically liberal state, is going to view the family from this very narrow perspective. Religion will view family from a much broader perspective. They have different ends. Religion might teach women that their role is nurturing, raising the children, etc., that it's not valuable for her to participate as a citizen, etc. And the point of political liberalism is to say, that's perfectly fine if you want to teach those values, right? But you cannot coerce women into abiding by them. So if a Muslim woman or an Orthodox Jewish woman or a Catholic woman wants to take on sort of traditionally masculine roles, right, the religious community will not be empowered to stop her, right? I agree with that 100%, right? My point is that there's nothing in arbitration, the doctrine of arbitration, that would ever allow a religious community to stop her from doing that, right? In fact, one of the points is that arbitration, when it comes to family law, is by the way it's set up, is going to be limited to an extremely narrow set of cases, right? And so it should not be the instance of raising so much anxiety, right? It's not the anxiety that is associated with allowing religious arbitration of family law disputes is not at all reasonably related to the set of concerns that they can have, that they can resolve, except unless one goes beyond that to start bringing in other kinds of considerations that are beyond the ken of political liberalism. Some of the things we talked about earlier in the day with the, I can't pronounce the Hebrew word, with the Orthodox communities and putting up
Eruv?
Yeah. I mean, you hear this argument, in Canada, for example, is that if Canadian courts recognize the results of Muslim arbitration, what's going to happen is that Muslim women are going to feel psychological and communal pressure to use these, right? Because they will be subject to criticism of being bad Muslims if they don't, right? And so there's this idea that even though the nature of it is voluntary and it only has jurisdiction over a very small set of issues, and it doesn't impinge on the freedom of a woman to leave, the freedom of a woman to pursue a profession, all these other sort of things, right? It has a kind of sociological effect of locking women into a religious community that will substantially narrow their lived experience of citizenship, right? That is sort of the parade of horribles, right? But from the legal perspective, there's no basis for making any of those assumptions, right?
It's hard to comment because it was a very sophisticated and very sophisticated treatment. I want to understand building actually I guess on Sam's point. Are you claiming that properly understood because there's multiple conceptions of equality, and because the jurisdiction, so to speak, of the arbitration is limited, that in fact there's really no conflict at all? Or because that's what it sounded like you were suggesting, that in fact there's a plausible conception of equality, that that any of the property allocations that you identify would satisfy, and hence there is no conflict at all between equality and religious liberty. Or that's what I thought you were arguing. Or are you arguing that there is ultimately conflict here between equality and religious liberty? I don't hear you making that second argument, and that religious liberty ought to win out.
Okay.
Yeah.
There is a conflict, I think, between equality and religious liberty, but those conflicts always are resolved in favor of equality from the perspective of public law, except for those cases, right, that involve sort of property. Like I said, so if you're an Orthodox Muslim and you believe that a wife has a duty of obedience, right, and she can't leave the home without your permission, this classical doctrine, right, you can't get that enforced, right, and there will be Muslims who adhere to that. Allowing Muslims to arbitrate family law will never, not in a million years, ever allow that rule to be applied.
Okay,
right?
but that's what I said.
Okay.
I said, given the limitations of what you say arbitration can order, which is to say it's only property, you're saying essentially that anything that's within the power of the arbitration panel to order cannot implicate equality.
Well, it cannot implicate equality in a politically meaningful way, right? Because we don't require strict equality in distributive justice in the family. Right?
Okay.
That's what I'm trying to say. Is that there's a idea, there's a notion that's sort of in the ether that strict equality in distribution of marital assets is a requirement of political liberalism. And I'm saying that's just not true.
Okay,
right?
so good.
That's not true.
Okay.
Right? And so the fact that Islamic law does not adhere to that, right, should not be counted as a strike against it, right?
But the permissible deviations within the secular side that you identified are predicated on real consent.
Yeah.
Okay, so then does that open your analysis to interrogation as to in the circumstances where you're advocating non-problematic arbitration, is to inquire whether there's meaningful consent that the parties, particularly the woman, gave? Is that?
Well, I think it's a general question, but it has to be asked generally and answered generally, rather than specifically to certain kinds of communities or subcommunities. For example, in Canada, one of the cases dealing with this, the prospective husband presented his prospective bride with a prenup on the morning of their wedding, right? But the court found no duress. Okay, I mean, even though thousands and thousands of dollars had been spent, the guests were there, she was getting her bridal gown on, oh, here's a prenup, right? So, but that was not considered duress. So, whatever the proper level of duress is, it's pretty high, right? Which I think, again, is sort of consistent with Rawls's idea that what we're concerned about is political voluntariness, not sort of actual. Because what does actual voluntariness mean? More generally, though, what I wanted to point out, and I didn't sort of develop this deeply enough, is I think there's a deep problem with this idea of relying on the family, on family law, and distribution of family assets to assure the financial security of women and children, right? Because the fact is, it's sort of random, right, how families are going to do economically, right? And a norm of sharing doesn't do women any good if the family has nothing to share, right? So one might say that the appropriate rule is that the public should bear the risks of these things, and the public should take a much more active role in guaranteeing the social security of caregivers and children, right? If we take seriously the idea that we care about the family because it reproduces political society over time, and that we need to compensate women for that, specializing that labor, well, it seems to me that the best institution to do that is the public, not the husband, whose resources are going to be variable in a very random way. So why should we say, if a woman has the bad luck of marrying somebody who's economically, obsolete or not productive or whatever, that her ability to get support is going to be reduced to that extent? It doesn't seem like a very rational system, right? So it seems if we, to take this seriously, we should not really look at family law as a way of compensating women for this specialization, but have things like public health, public daycare, et cetera, all these other kinds of services that the socialist countries provide, which aren't really on the table here. But that seems to be really the best optimal solution. Right.
Really enjoyed that. Very extremely sympathetic to a lot of what you said. I guess one of the things that I wanted to ask about, although I'm not sure at this point, kind of your use of unconscionability. And I guess when I've made similar arguments, I get pushed back, at least in the American law context, on two fronts, and I'm curious kind of what your thoughts are. One is kind of the way in which American doctrine splits up unconscionability into procedural and substantive elements. And so in almost all jurisdictions, not all, but almost all jurisdictions in the United States, mere substantive unconscionability is not going to be enough in order to, let's say, void an agreement. And so in that way, it seemed like at certain points you wanted to use unconscionability as a backstop, and I'm completely with you on that. I'm just curious what you think about that, maybe what the relationship is between that and some of the questions you were getting about duress and things like that. And then the second part of the question, I want just, again, teasing out some of this unconscionability stuff. The other kind of pressure point I get from arbitration scholars is that unconscionability under U.S. doctrine can only be used to void an agreement, not vacate an award. So once you've participate in arbitration proceedings, you actually typically, there's complicated arguments, maybe why not, but typically you've waived your right to challenge the validity of the agreement. And so you end up in this bizarre situation where by the time many people realize that the agreement is substantively unconscionable, A, they're stuck on making a procedural unconscionability argument, and B, they may have waived their right to raise the argument in its entirety. Because once you participate in proceedings, again, in most jurisdictions under federal and state law, once you participate in arbitration proceedings, you waive your ability to challenge the underlying agreement. So I guess that's the pushback I get. I'm curious what you think about that.
I don't know enough about the details of unconscionability doctrine, because the family law principles of the ALI sort of make it clear that you should have, the courts have a right to vacate an unconscionable arbitral award. So I don't actually know how that's applied. So I'm sort of speaking more from a philosophical perspective, right? But I've always viewed unconscionability as sort of a black hole. You don't really know what it means, right? But the basic idea, I think, what Rawls is getting to is, the basic idea is a woman should not be left in a position where she's a pauper after she had been living sort of a decent life, right? So it's kind of like I know it when I see it type of thing, right? And so, I take it that there's a risk of something like that, and that's why there needs to be public supervision of these things. But I don't think, which seems to be the argument, is that the application of Islamic legal principles inevitably leads to this result, right? That's what I'm trying to respond to, that there is no, there's nothing inherent in Islamic property law that will inevitably lead to the pauperization of divorcees. Right? Now, it might happen because of, there might be a woman who's extremely naive, unable to assert her rights, blah, 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 for the same reasons why we have unconscionability doctrine generally. But it's not something inherent in the legal norms that should be dignified.
That, I think, brings an end to not just this lecture, but the conference in general. Thank you to my co-organizers,
There is a reception in the back.
There's a reception in the back for anyone who wishes, a little bit of snacking.
No, they're talking.
In a way.